Guys, thank you so much for being here. Become a contingency ninja. We were actually having a conversation. Kristen and I were having a conversation a couple weeks back, and I was introduced to Kristen by my amazing friend and super today, Ms. Marilu Bailon. Thank you so much for making this amazing introduction. She said, you have to talk to my friend Kristen. And I said, okay, I'll talk to your friend Kristen. And as soon as I started talking to her, and obviously this is her good business partner, Sanam, as well. We just want to, also acknowledge that she's here. Sanam and Kristen also work together. First time we're actually connecting. So thank you so much for being here. But very, very amazing conversation that I had. I was like, wow, this is really awesome and powerful information that everybody needs to know. And I would love for you to do a training and a class. That way we get everybody integrated and ramped up. And, it's a really hot topic, right? We're in transactions. We're dealing with buyers, obviously with sellers, and the contingencies when you remove it. Do you get the deposit? Do you not get the deposit? I mean, we're going to be covering, I won't be covering it. Kristen will be covering that information today. So get this, guys. Kristen has been part of 25,000 plus transactions. So she definitely is a contract ninja. She knows what she's doing, and I'm super excited to welcome her and Sanam to our training today. So thank you so much for being here. I'm excited to hear a little bit more about you and the class that you have for us today. Thank you.
Thank you, guys. Thank you for having us. I'm going to do some screen sharing real quick so that we can see some PowerPoint going on. Okay. Oh, that's not it.
It's all good. It's all good. Okay. Thank you. Thank you. Thank you. Thank you. There you go.
Becoming a contingency ninja. And of course, since we're attorneys, we've got to give you the fun disclaimer of, hey, not to be construed as attorney-client relationship by this and that sort of thing. We're totally happy to answer any questions that you have. My business partner, Sanam, is going to be monitoring the chat. So if you have questions, please feel free to talk in the chat there with any of those questions. And then we also saved a little bit of time at the end of our hours so that we can answer some questions live if you have them.
Awesome.
Okay. Today, we're going to cover all of this, which is a lot. So I hope you drank your coffee this morning, ate your Wheaties, because it's going to be a jam-packed day, but I promise that everybody will learn at least one thing. If you're a new agent or a seasoned agent, that's my guarantee. As much as attorneys can't make guarantees, you're going to learn at least one thing today. But first, some information about your presenter, me. And also Sanam. I was previously in-house working with thousands of California realtors. Before I transitioned into real estate, I was a senior associate with a big law firm, Wood Smith, Henning & Berman, handling multi-million-dollar lawsuits. Went to UCLA, graduated with Latin honors, and then a Chapman with a full tuition scholarship, where Sanam also attended with a full tuition scholarship. And it is presented by our law firm, which is Wait Real Estate Legal. Good things come to those who wait. We are a real estate law firm, and our whole goal is to make life easier for brokers and agents. We're women owned and operated. We serve all of California through a virtual office. So you can call us, you can text us, you can email us, you can Zoom us, although we're physically located in Corona Del Mar. And as Sanam said, she is fluent in Spanish and Farsi, but we are both fluent in English and agent. And again, bear with me here. I'm going to be pitchy for like just 2 minutes, and then we're going to get into our feature presentation. Okay, so part of the reason why I wanted to get in front of you and why I'm so excited to be working with Leo is that we have this thing that we call our Legal Lifeline Club. And basically, when agents join, it gets them premium direct access to our team of attorneys for pre-litigation or pre-arbitration, their California real estate transactional assistance, and ethical compliance. So this includes like everything from questions about car forms to resolving hostile transactions. It includes like demand letters and settlement agreements on your behalf related to those transactions. Sometimes it requires broker consent. Those of you that have worked with me in-house before, this basically gets you access to a lot of the things that we used to work together with. During normal business hours, we try to respond that day or the next day. We really try to be on top of it because we know how the time periods are important under your transactions. We're also available after hours on the weekends for emergencies. Just text us. And once you've signed up, you can start contacting us immediately via call, text, email, or Zoom. If you have a general question, we just need your name and your broker. And then if it's a transaction question, we'll ask you for the property address and the names of the parties involved, just so we can do a very quick conflicts check. While we cannot promise or guarantee results, our clients have been thrilled when we've basically saved their troubled transactions and gotten them paid. That's what we're all about. And the cost works kind of similar to a TC, as in we get paid when you close escrow on your transaction. It's a flat fee per side for every real estate transaction. The agent closes while they're part of the club. It's payable at close of escrow through the escrow, and it's owed for like every transaction you close while you're part of the club. But if you try it out and decide, it's not for me, you can just email us and let us know, hey, I don't want to be part of it anymore. And that's no problem. The fee we charge is roughly the cost of a TC, but Leo and Marilou, with their strong negotiation skills, actually got very special pricing just for EXP agents. Since we have some non-EXP agents on, I'm not going to disclose that pricing because it's a really good rate. It's even less than the cost of a TC for you guys. So if you are interested, you're going to want to make sure to join us. But let me give you some of the deets first. It's capped at 10 hours per transaction. It includes like issues related to your real estate transactions or compliance, but not like unrelated personal questions like, hey, what do I do in my divorce? Talk to a divorce attorney. We're not a substitute for TCs, but we won't like prepare your transaction documents, but we can absolutely guide you on how they need to be prepared and what boxes you need to check, and how you fill out an addendum and that sort of thing. We don't do property management, business brokering, taxes, trust funds, or criminal law, because we try to focus on things that we're really good at. And it doesn't include things like audits, litigation, arbitration, or hearings, for the main reason that usually at that point, that's when your E&O is involved. This kind of is meant to prevent E&O from having to become involved, and also meant to hopefully save some of your transactions. We don't represent the buyers or sellers in the same transaction because we try to avoid those conflicts. It doesn't cover your past transactions, only the ones when you're part of the club. And then if there's other clients that we have, we only represent and charge the first brokerage that contacts us concerning any individual transaction, so that we can advocate for you fully on that transaction. If you're interested in it, please go ahead and email us at contact@waitlegal.com, or there's a link right here. Sanam, if you could put that link in the chat too. You can also fill out the information on our website, and that will automatically give us what we need so that we can shoot you an email with the pricing, the special pricing for EXP agents, and also like the contracts so you can sign up. And then you'll be part of it, immediately as soon as you sign. So
also, guys, make sure that you guys follow Kristen, their Instagram page. It's full of really valuable information. So give them a follow, please. And also give them a shout out. She's going to be dropping a lot of amazing information. So give her a shout out. Let her know you guys are getting value in the presentation. So just wanted to interject there.
Yeah, our social media, we're literally doing daily educational content for agents. And as opposed to this, which is like a lot of information at once, those are like little, amuse-bouches of education. They're little tidbits. So they're the perfect, like when you're waiting in line at Starbucks kind of thing.
Yep. I love them. They're really good. Thank you.
Okay, and now for some learning. And here's a picture of my daughter, whose future college education fund depends on people signing up for our Legal Lifeline Club. So let's get started. What is a contingency? So basically a buyer or a seller with the contingency can cancel if a certain event happens or does not happen, which I know is a weird concept for agents. So the best way that I can explain it is by using an example. So let's say you're throwing a party and your friend says, if I can get a babysitter, I'll come to the party. Her attendance to the party is now contingent on her getting a babysitter. That's kind of like if you're selling a house. Hey, if I can get my loan approved, I'll buy the house. The purchase is now contingent on getting the loan approved. So a good friend is going to make a good effort to actually get the babysitter. She's going to call a babysitter. She's going to, try to see if she can actually get one. Much like a buyer actually has a good faith effort if they have a loan contingency to try to get the loan. They've got to fill out some loan applications and that sort of thing. So that's kind of a real life example of a contingency. Let's go over some of the most common buyer contingencies. So you'll notice that there's way more contingencies for a buyer than for a seller. Hey, Kristen, why is that? Think about it. Fundamentally, the reason why buyers are going to have more contingencies is buyers have less of an idea of what they're buying than sellers know what they're selling. So that's the reason why it's usually a lot easier for a buyer to cancel than for a seller to cancel in general. So we're going to get into some of these in detail now as far as the buyer contingencies. So first and foremost is the loan contingency. And you'll see on my PowerPoints as we're going through, the first time that I've listed a contingency, I've put the RPA section that relates to that, and also in the contingency removal, what section relates to that contingency, just for your future use. So a loan contingency basically says that a buyer can cancel if they can't get a loan. Pretty straightforward, but then it gets a little bit more complicated. So your buyer has to actually try to get the loan. They have 17 days by default under the RPA. Now, the biggest issue that I see a lot of agents do, which is very important in this market where interest rates are getting sky high, is that a lot of agents forget to actually fill out the terms of the loan contingency in this RPA section 3E1, where it talks about the loan rates and the points. The reason why that's incredibly risky is it risks your buyer. Basically, you've agreed that they'll get a loan, but you have put none of the information of the terms of that loan. And with interest rates going very high, you could risk the buyer having to accept any loan. I've even heard some people try to argue that they don't even have a binding contract by not filling that out. To me, that seems a bit extreme, but the long and the short is make sure you complete this with the actual percentage and points. And if you're not sure what to put in there, hey, I don't know, I don't deal with loans. Well, my tip for you then is say, hey, buyer, are you okay with us putting the loan contingency terms, having it match the pre-qualification that you got from the bank? Because that's at least a guiding point. Okay, so one thing to be clear is loan contingencies and appraisal contingencies, those are separate contingencies. So if a buyer had removed the appraisal contingency and the property appraises low, the buyer cannot use that low appraisal to cancel under the loan contingency. Speaking of which, let's move on to the appraisal contingency. So when you have an appraisal contingency, this basically says, hey, the buyer can cancel if the property does not appraise for the purchase price. One point to be clear is that this is a contingency for the buyer. If it doesn't appraise, the buyer may cancel. The seller does not have any cancellation rights under that appraisal contingency. And it's 17 days by default in the RPA. One tip that I wanted to note right here, especially with what we've heard in the news recently with the FHA mortgage insurance reducing, I'm sure we're going to be seeing a lot more FHA loans. So don't forget that if you have an FHA or a VA loan, that they basically act as kind of an exception to low appraisal contingencies, because an FHA or a VA loan requires that CAR form FHA VA amendatory clause. It is legally required. And basically what that clause says is that if it's an FHA or VA buyer who has, even if they've removed their appraisal contingency, if that property appraises low, that buyer still gets their deposit back for that low appraisal and can cancel. So just remember FHA and VA loan, hey, I'm removing my appraisal contingency. Yeah, cool, that's kind of meaningless, right? So just don't forget about that. What do you do if you have a buyer that wants to pay $1 difference if it appraises beneath the purchase price? So they had updated the CAR forms to this. And basically what this says is that you would check the box here and put in the dollar difference between here and the purchase price is the money that the buyer would need to come out with, the difference between what's listed here and the purchase price. So that's the way that you would create a contingency where it has to appraise just for less than the purchase price. Now, that got a little bit trickier with the December CAR forms updates, because the December CAR form updates now says in the counter offers that that if you've used this section, then in your counter offer the price has increased, that the appraisal contingency basically is automatically adjusted upwards by that price increase unless you've otherwise agreed. So let me give you an example of that because I think it's easier to understand with an example. So if you had an original purchase price, $500,000, this little box was checked here that said 400,000, meaning the property only had to appraise at 400,000. The buyer's difference in that situation between the appraisal contingency and the purchase price is $100,000, essentially, that the buyer's going to have to come up with in cash, right? But let's say the counter offer said $550,000. The buyer's difference between the appraisal contingency and the purchase price would still be the $100,000. So that would effectively be treated as though this section said $450,000. Does that make sense? Kind of one of those weird things that they just updated. And again, if you have questions, please feel free, put them in the chat, and I will also take live questions at the end too. Contingency for sale of buyer's property. Okay, hold on to your hats. This one's a little bit complicated. Now, I know we didn't see a lot of those last summer or particularly for the last 2 years, but I have a feeling that this summer they're coming back as the market's shifting. So this is where the buyer's purchase is made contingent on entering into a contract to sell and or closing on buyer's property. The way that it's used is you're going to check the box in RPA section 3L8, and then you're also going to want to complete a CAR form COP. Whatever you do not write it on a regular addendum. This is a rookie mistake. I've seen agents do it. And the reason why you don't want to just put it on some regular addendum and you want to use that CAR form COP is the way that the COP is completed matters significantly. Well, let's get into that. So first, it matters just for what the kind of contingency it is. So this is the COP form. If you look at this section 1A, it defaults here to being contingent on the buyer entering into contract and closing on buyer's property. But if this box had been checked here for 1B instead, it becomes contingent only on entering into the contract to sell buyer's property, not contingent on buyer actually closing on the sale. And then if this box instead had been checked for 1C, that basically is contingent only on buyer closing the sale of buyer's property. So like you would use that if your buyer had already been was already in contract to sell it. So the way which box is checked or not checked here really matters for, hey, is it contingent on entering into a contract to sell, on closing it, or on both? How the COP is completed also matters for the length of the contingency. So if it's contingent on closing the buyer's property, meaning we leave it by that 1A or we've checked that box for 1C, then the COP form defaults that this contingency lasts until the close of escrow of this property. What does that mean? So if buyer's sale falls out of escrow the day before you're set to close escrow on this transaction, the buyer can still cancel because it lasts for the full length of this escrow as well. However, if this box is checked in section 4, then the buyer would have to close their sale at least 5 days before the close of this purchase. So if you're a listing agent, you're probably going to want to check this box, right? Because we know how difficult it is to get those simultaneous closings. And this at least gives the seller, you know, a few days where they know, hey, okay, cool, buyer can't just pull out and cancel without being in breach of contract. How it's completed also matters for the time periods and even the time periods under the purchase agreement. So the COP form defaults to the time periods that are in the purchase agreement or the time periods in the purchase agreement. Great. But if somebody has gone in and they've checked this box by section 11A, what this means is that counting under your purchase agreement doesn't begin until after the buyer's contract is in contract to sell. What does that mean, Kristen? Okay, so let's say that the COP form, this contingency for sale of buyer's property, was made contingent on buyer entering into contract and closing under, by default, under section 1A of the contingency for sale of buyer's property form. In that case, by default, the buyer is going to have 17 days to enter into the contract to sell their property. That's covered in section 2A. And if this box was also checked, then in that situation, your like 30-day offer actually becomes 47 or more days until close of escrow, because you don't start counting 30 days until after those 17 days have passed and the buyer has already entered into a contract to sell. So that's why how this is completed really matters for time periods into the RPA, because you could think, oh, good, we're going to close real quick. I have a 30-day offer, but it actually ends up being, 47 days, if not more. How it's completed also matters for seller cancellation rights. If your seller is trying to cancel to get out of a contract and the contract has a COP, then you definitely want to review the 2 sections that I've listed here, because it also contains some seller cancellation rights about like backup offers or about the buyer not performing. We're not going to go into that in detail right now because there's a lot of other info we're trying to cover today. Okay, moving on to the investigation of property contingency. Oops, sorry guys. So investigation of property contingency, it is a BOGO, it is a buy one, get one, it is a 2-in-1 contingency. So the first one of it is physical attributes and items connected to the property. And the CAR forms gives you this inspections of physical condition of land and improvements. What the heck does that mean, Kristen? Oh, okay. Well, what that means is like your home inspection, your lead paint inspection, your termite, your mold testing, your land survey. These are things that are like physically connected to like the property or the land the property is on. That's like the first half of the investigation of property contingency. The second half is this like other buyer investigations. And it's like, what the heck was that supposed to mean? Oh yeah, and then they changed it in December too and gave you a new definition of it. Not confusing at all. So what the CAR form says now is it's the investigation of any other matter affecting the property other than those specified in a separate contingency. Super clear, right? No, not at all. Okay, so the examples that you have for that are things like permits, neighborhood schools or noise, crime, zoning, etc. One very clear example of this is insurance. So here's a big tip. If you only have one takeaway, especially if you are selling in a high fire area, if you are a buyer's agent in a high fire area, I know we have a lot of them over in Corona nearby me, you want to advise your buyer to shop insurance before they remove their investigation contingency, because insurance is not part of the loan contingency. It's part of this buyer investigations contingency. So you do not want to be in a situation where you've already removed the inspection contingency, allowed your buyer to do that, and then your buyer finds out they can't get insurance at that property, or they're having to get insurance with incredibly high costs and things like that because they're in a high fire area. So don't forget, insurance is part of the other buyer's investigations contingency. It is not part of the loan contingency. The investigation contingency is the broadest contingency. It's like the motherlode of all contingencies. The buyers can cancel based upon their subjective standard of which conditions and other matters affecting the property are unsatisfactory to that buyer. So one tip for that is the ability to cancel under the investigation contingency, in my mind, is what gives the buyers some bargaining power in negotiating repairs. So for example, let's say there's a termite inspection that shows repair work needs to be done. It wasn't agreed to. If the seller won't repair and the buyer hasn't removed their investigation contingency, then the buyer can cancel and get their deposit returned. And because the buyer can cancel in that situation, because they had that investigation of property contingency, that's what gives that buyer a little bargaining chip with the seller of, hey, seller, please agree to it or I will cancel. So I know that we saw, especially in recent years, a lot of upfront removals of contingencies. I think as the market shifts, though, we probably want to reconsider whether or not it makes sense to be removing, especially our investigation of property contingency upfront. It is a 17-day contingency by default in the RPA. And one thing to be aware of is that the investigation of property contingency is separate from the right to conduct inspections or investigations. So the informational access to the property is actually right here in the RPA 3L in the second box, and it defaults to 17 days. So if a buyer has removed their investigation contingency, that buyer can still inspect the property. They just can't cancel based on those inspections. Reverse is also true though. Just because the buyer hasn't yet removed their investigation contingency, that doesn't automatically give the buyer more time than what's listed in here for their inspections. So you definitely want to make sure if you're a buyer's agent that you are on top of scheduling those investigations, or if you think that you're going to need more time to do your inspections for whatever reason, there's something unusual there, you're going to use this box and put in a longer period of time for inspections. And frankly, in that situation, use this box too and extend your investigation contingency too. Okay, are we absorbing all that? Moving on to the next one. Okay, next one. Contingency for review of seller documents. This is another contingency built into the purchase agreement. And it basically says buyer can cancel based on buyer's review of seller's documents, and it like cross-references all these other sections in the form and gets a little confusing. So what I've done for you is there is a list on the screen that is basically the documents that it's referencing to as best I can tell. And it's things like your TDS, unless the seller is exempt, your SPQ, your ESD, your NHD, that fire hazard defensible space form, that sort of thing, HOA documents, prelim report, solar panels, warranties, government points of sale inspections, like a city pre-sale inspection, that sort of thing. That's separate from the investigation contingency, and it defaults to 17 days for the buyer to remove it. Now, one big tip to note here is that this includes the listing agent's avid. So listing agents, do not let the buyer cancel because you waited too long to do your avid. You do not want to be in the situation of having to explain that to your seller of, what do you mean? I did all my disclosures up front. Yeah, but I waited too long to do my Avid and get it to the other side, and that triggered cancellation rights. So now the buyer can cancel and get their deposit back. You don't want to be in that situation. Also be aware that's only based on the listing agent's visual inspection disclosure Avid. It's not based on the buyer's agent's Avid. So you can't just like have the buyer's own agent wait to do it and then cancel based on that. It doesn't work that way, only for the listing agent. Okay. So that's, for the most part, it on buyer contingencies. But now let's talk about something that's very commonly related to that is, hey, can the buyer cancel because of new information? Well, if the buyer has already waived or removed their contingencies, but there's new information discovered, can they cancel? And the answer to that is sometimes, and it depends on the situation, and attorneys disagree on the interpretation under the new RPA, which is so new, there's not even a whole lot of case law we can pull from. So with that, this is my best interpretation, but it is a fact-specific analysis, and there's also other facts that could come into play depending on what the new info is, and if it's like catastrophic destruction of the property or something like that, then a whole other set of rules are going to apply. So this is my best interpretation, but take it with that kind of grain of salt of no one's entirely sure exactly what it means with some of these things. Okay, so if it is new information that is based on an updated TDS, NHD, that fire hazard disclosure statement, or the listing agent's Avid, then the buyer has 5 days after it's emailed to cancel, even if they've already waived their contingencies, because that is built into California law. But the RPA talks about if a seller or a listing agent becomes aware of adverse conditions materially affecting the property or any material inaccuracy to disclosures previously provided in certain disclosures like the TDS, the NHD, the SPQ, the ESD, the fire hazard disclosure statement, or the Avid, then the seller has to provide an amended disclosure. It says that in the purchase agreement. And in that situation, it might trigger buyer termination rights. And then the RPA talks about, however, an amended disclosure is not required when the buyer is otherwise aware of that condition or inaccuracy, like the defect is obvious, right? You don't need like an updated disclosure of there was a giant crack in the driveway when, as long as you didn't have that driveway covered with cars every time the buyer's been at the property, it's going to be pretty obvious. So it's not required when the buyer is otherwise aware of the condition or inaccuracy, or it's not required if the buyer discovered or it's disclosed in reports or documents that were provided to or ordered and paid for by the buyer. That's what it says in the purchase agreement, basically trying to have the buyer assume some of the risks of reading the buyer's own documents that they've been provided. That being said, even though the contract says that amended disclosure is not required, I also want to add in that if the seller knew something and failed to disclose a material issue to buyer, even though the purchase agreement talks about, hey, an amended disclosure is not required, that is just kind of like asking for the buyer to sue for a non-disclosure issue. So if you run into that situation where there is new information and what do you do with it? My short answer there is this is exactly why we have this legal lifeline club that we're offering to agents, because this sort of situation is so tricky. And the way that you handle, hey, is the seller going to disclose, or they're going to say that the buyer already had it, and that sort of thing really depends on the facts, and is really something that I highly recommend that you consult with an attorney, or at the very least, like your office manager, your branch manager, your broker, that sort of thing about, because it can have major implications for if you can save the transaction or cancel the transaction, that sort of thing. How does a buyer cancel under contingency? Okay, well, a buyer can cancel under contingency if they have all three of these things. If they haven't removed that contingency, if the reason for canceling is under that contingency, and they acted in good faith. And if they've done all those three things, then the buyer should be entitled to the deposit back, but never promise or state to the buyer that they'll get it back. Remember, agents cannot provide an opinion on if they had acted in good faith, because that is providing legal advice, and you don't want to do it because it's one of the quickest ways to get sued and to also have issues with like the National Association of Realtors Code of Ethics, which says that you can't provide legal advice. So never overpromise, never overstate. You can say, hey, buyer, yeah, the contract does say that the seller should release the deposit, but I can't make any guarantees or promises about that. Sometimes there's hoops that we have to jump through to get deposits back. And we'll talk about those in just a minute. So
Yay. Kristen, I wanted to get some feedback from everybody. Guys, if you guys are tuning in, listening in, or you guys are getting value, drop it in the chat. Get Kristen some feedback. Is this valuable? Drop some emojis, drop some fire, say value, say something. I want you guys to give feedback
you
because it makes
here? Are
such a
you
difference.
alive?
Yeah, are you guys alive? You guys still breathing, right?
Are your brains
All right.
hurting? Did you learn something? That was like I said, I
Yeah,
was
yeah.
guarantee you learn at least one thing.
All right, cool. We got a fire emoji. We got value. We got woo. We got great gems, great
Are you
information,
feeling halfway
incredible
into
value. Needed
halfway
this. Boom. There we go. Awesome. Awesome. There we go. More fire. Let's
Okay.
go. All right.
Guys,
All right.
we're good. We're about like halfway through. So like you should feel half ninja'd right now. Like
Yeah,
you're getting
half ninja.
right?
There
You're a
we
little
go.
limber, your brain's doing some good stretches.
Yeah,
Okay.
very good stuff. Thank you.
Okay. Great, guys. Sorry, I'm only making you small because I want you to be able to see the full PowerPoint. We'll put this down here. Okay, let's talk about how you complete the cancellation, the car form CC, when the buyer is canceling for under a contingency. So on the top half of the form, you check the box for buyer, then you're going to check the box right here for 1A, and you're going to write in the paragraph related to that contingency. And in the bottom half, you're going to check the box for section 2C1, which says the deposit is released to the buyer, less buyer's fees and costs. And I know agents tend to freak out over this term of, hey, what's that buyer's fees and costs mean? My buyer should get their full deposit back. Well, what that's talking about is it's talking about things like escrow cancellation fees or costs that the buyer has already incurred to be paid through escrow, like if they had a home inspection done and it was supposed to be paid by the buyer through escrow. Just because they're canceling, like, doesn't mean escrow is not going to charge those to the buyer. So that's what that's talking about when they say less buyer's fees and costs. And I know the next question is, well, okay, so I'm supposed to write in the paragraph related to that contingency. How do I know which paragraph do I use? Okay, this I'm very excited about. If you learn one thing today, like this is the thing to learn because this is the hack that will save you time. So this is your cancellation form, right? Buyer's canceling, you're checking the box as permitted by the good faith exercise of paragraphs blank of the agreement. But which blank do I put in? So if you had used an RPA, what you're going to do is you're going to pull up the car contingency removal form. So you pull it up, and on the contingency removal form, it lists all the contingencies, and next to it, it lists what paragraphs in the RPA talks about those contingencies. So let's say your buyer's trying to cancel under the loan contingency, and you're not sure what to put here under the cancellation of which paragraphs relate to the loan contingency. Cool. You pull up the contingency removal form, you find where it says loan contingency, and you plug in, as long as you used an RPA, you plug in the paragraphs that are listed next to that loan contingency on the contingency removal right here in this cancellation, which basically means you have just saved yourself having to read through the entire 20-page purchase agreement to find the paragraph to plug in. Does that make sense, guys? Can I get a little yes, no? I'm gonna pull up some faces because this to me is honestly one of those sort of things that I do that I know has saved me time. And but it's a little bit tricky to explain. Yes, makes sense. Cool. Okay. Let's talk about waiving contingencies. So believe it or not, some contingencies cannot actually be waived under law. Those are things like certain lead-based paint disclosures in like older homes and inspections. And then the other thing that a lot of agents don't realize is that if it's a 1 to 4 unit home, unless it's exempt, the seller actually has to give the TDS to the buyer, and that TDS must include the listing agent's avid. The buyer then has the right to cancel within 5 days of when that TDS is emailed. And that's something that can't even be waived. So you see sometimes, hey, they've already removed all of their contingencies. They can't cancel, right? I'm good. Well, no, not if you haven't already given those disclosures out. Now, the only exception to that is, let's say, especially in NorCal, we see this more where they give disclosures up front. If that TDS was given to the buyer before the purchase agreement was signed, then in that situation only, that TDS termination right can be waived. Otherwise, the buyer is going to have 5 days after when it's emailed to cancel. Also be aware that just because your property is being sold as is that doesn't get you around these rules. A lot of agents don't realize as is language is already built into the purchase agreement by default. And the seller is still obligated to disclose any of their like known material defects, any issues that they're aware of with the property. Let's talk about making a non-contingent offer. We saw a lot more of these the last couple of years. It is very risky for the buyer to make a non-contingent offer. And CAR actually did something to help for that. In December, they released this new CAR form. That's why it's highlighted in blue, because it's a December update. They released this CAR form called non-contingent offer advisory. And basically what that does is that helps advise the buyer of the risks of a non-contingent offer, but it's also like kind of a sort of get out of jail free card for you as an agent, because it is something that you can send over to the buyer, have the buyer acknowledge, save that in your file so that the buyer can't later say, hey, you didn't advise me about the risks of making a non-contingent offer. Oh, yes, I did, buyer. Remember, here was this form. We looked at it. You signed it, that sort of thing. Another tip with that too is when you have a buyer who's making a non-contingent offer, or if they're waiving contingencies, it's generally a good idea in that situation to advise the buyer to consider a lower deposit and to use that little indented liquidated damages clause to make sure buyer and seller have both initialed that, because basically in that situation, you are in hopes limiting the amount of money that the buyer would have to lose if they did decide to cancel and be in breach, because there was that lower liquidated damages amount agreed to. And hopefully that makes sense and isn't going over your heads, but we're not going to go over into liquidated damages today. That's a whole topic for another day, but that's just a tip there of, hey, don't forget, if you're making a non-contingent offer, generally you're going to want to have a lower deposit and use liquidated damages and use this CAR form non-contingent offer advisory if you're representing the buyer. Okay, big breath before we move on to sellers. For most of the way here, thank you for hanging in there with me, guys. This is a lot of information. It is not easy to handle contingencies as agents, and honestly,
Sí, 2 casas por $800 al mes.
Whoa, yeah, sorry. Let me go ahead and hit Mr. Mute. Here we go.
Sorry, guys.
All right.
It's a lot of information. I get it. This is exactly kind of part of why we've done this whole Legal Lifeline Club, is because I think it is nice for agents to have someone that they can talk to when they're trying to figure out, hey, can I cancel based on this or that or the other? And especially someone who's going to actually like pull up your contracts and take a look at them and help you fill out some of those forms too, especially when you're dealing with the cancellations or inability to cancel and that sort of thing. Anyway, moving on to seller contingencies. We're not going to go over all the seller ones because they're a little bit more straightforward. And there's really kind of 3 main ones that you see for seller, which is the replacement of property contingency, the short sale approval, and the probate court approval. The only one of these I'm going to go over today is the replacement of property contingency, because you guys have had more than enough info thrown at you today, but you'll see why this one's important to go over. Especially this summer, I think we're going to be seeing more of these. So basically the seller's sale is made contingent upon the seller entering into a contract and or closing on a replacement property. And the seller has to, in good faith, attempt to find a replacement property. So how would you incorporate that into it? The counteroffer could say something like, the seller's purchase of replacement property attached here to is incorporated herein by reference. That's kind of the type of language I'd recommend using. So I'm going to just like leave this on the screen for just a second so you guys can like take a picture of that, because there's no like default other way in a counteroffer to incorporate that language. Okay, so and please be aware that if it says on the MLS, hey, the purchase is contingent on, that the sale is contingent on seller's purchase of a replacement property, but it doesn't make its way into the contract, then it's not contingent on seller's purchase of a replacement property. And I've seen agents make this mistake more times than I can count, and it's not a great conversation with the seller to have of, oops, I forgot. So please, if your seller does want it to be contingent, make sure you have used CAR form SPRP and that it's been incorporated into your counteroffer or into your purchase agreement. Okay, remember when we talked about the CAR form, COP, the contingency for the sale of buyer's property? this form's gonna seem sort of similar to that, but also the reverse of that, which is why we're going over this in detail. So the CAR form SPRP, the way it's completed matters for the kind of contingency. So it is the opposite of CAR form COP. This one is defaulting to it being contingent just on the seller entering into a contract to buy a replacement, which is the opposite, of course, of how the COP defaults for buy or sell. So but instead if this box by 1B is checked, then that's basically when the seller has already entered into a contract to buy it. And if you're using this box for 1B, then, and you're in all likeliness going to also want to check this box for 1C that makes it contingent on closing of the purchase of seller's replacement property. So if you're representing the seller, usually what they're going to want is this box to be checked because they don't want to have to be forced to sell their house if they don't already have a house that is going to close that they're buying on, because they don't want to be left homeless. So you definitely want to make sure you actually check that box if you're representing the seller. Because otherwise, by default, it's just contingent on them entering into a contract to buy a replacement, not closing on that replacement. How it's completed matters for the length of the contingency. It defaults to the seller has 17 days to find a replacement. If the box had been checked by 1C, then it becomes contingent on closing of the replacement property, like we just talked about, and it lasts all the way until the close of escrow of this property. So let's say your seller falls out of escrow, the day you're set to close on the seller's sale, that seller can cancel, kind of like how we talked about with the COP. So you've got to make sure that you know how these forms work in relation to who can cancel and who can't cancel and when. How it's completed also matters for the length of the contingency. So if it was contingent on finding a replacement property and the box was checked for 2C for closing of the replacement property, then the way that it works is when the seller removes that finding a replacement property contingency, what's listed right here says that the seller has the option to extend the escrow on this sale by the number of days that are written in this section. It's basically a seller gets these days free card if this has been already completed. So let me give you an example of that. Let's say the purchase agreement says you have a 30-day escrow and the seller needs to find a replacement property. The box had been checked for 2C and 15 days, that's this 2C and 15 days is written in. So the way that it works is that when seller is removing that finding replacement property contingency, seller can then notify the buyer, hey buyer, I am triggering this extra 15 days. So we are now going to have a 45-day escrow because you already agreed to this 15 days buyer right here. Right? So you see how this is completed really matters for how long is this transaction going to take. It also, how it's completed matters for the time periods in the purchase agreement. So if it is contingent on the seller finding a replacement property, it defaults the time under the purchase agreement doesn't begin until after the seller removes the finding replacement property contingency, which is frustrating because this is the opposite of how that CAR form contingency for the buyer, the COP form defaults. So what does that mean, Kristen, in English? What this means is that basically your buyer's contingency period doesn't start until after the seller removes the finding replacement property contingency. And if you don't want it to work that way, then you got to check this box under 2A for time periods to remain like it is in the purchase agreement. So let me go just real quick. So in that kind of situation, what you could have theoretically is that same, hey, a 30-day escrow then becomes 45 days. So you have your first 17 days for the seller to find that replacement property. Seller removes that finding replacement property contingency on that 17th day, right? So day 18 becomes kind of like day 1 then for the buyer's contingencies. So that's why knowing whether or not you want to check this box, depending on what your goals are with the transaction, really matters and really can affect your time periods. And again, this is part of why we have this Legal Lifeline Club, because it's not easy stuff to know how to manipulate some of these things. And these are the kinds of questions that we deal with all day long. Can a seller cancel under a contingency? Yes, the seller can cancel under one of the seller's contingencies if they haven't removed the contingency. The reason for canceling is under a contingency, a seller contingency, and the seller acted in good faith, kind of like with a buyer for buyer's contingencies. If the seller cancels under a contingency, in that situation, the buyer should be entitled to the deposit back. And the way that you would complete the cancellation is the top form, you check the box for seller, then you're going to check the box for section 1A5 and write pursuant to describe whatever the contingency is. There's not a cool hack for this one because there isn't like the equivalent of it. So just screenshot this language of you're going to want to check that box and write pursuant to and describe the contingency. In the bottom half of the form, you're going to check the box 2C1 for the deposit to be released to the buyer, less the buyer's fees and costs. What do you do if they won't release the contingency on time? Well, one of the things that you can do is you can send a notice to perform, be that a notice to the buyer to perform or a notice to the seller to perform. Keep in mind, like that only works though if the seller has fully performed. So for example, a seller can't deny access to the property for any inspections and yet like demand the inspection contingency be removed. A lot of agents don't realize this, but your notice to the buyer to perform or your notice to the seller to perform can actually be sent up to 2 days before the contingency expires. And then if the buyer seller doesn't perform, then basically your client has some options then. They could try to negotiate an extension of time, they can wait and see, or they can cancel. But please be aware though that when you do those notices to perform, they have to be done 100% properly, or it makes the whole notice to perform like invalid and you can't cancel. It says that in the purchase agreement, you have to like send it again and do it the correct way. So just be careful and make sure you know what you're doing when it comes to those notices to perform. Also, please be aware that a seller who cancels after delivering a notice to the buyer to perform to remove a contingency must authorize the release of the deposit back to the buyer. It says that in the purchase agreement. A lot of sellers are really surprised by that because they go, oh, but the buyer didn't do what they were supposed to do. They didn't remove the contingency. I had to send them a notice to perform. Yes, I hear you, seller, but that's not one of those situations that triggers the deposit. It actually says in the purchase agreement, the deposit's supposed to go back to the buyer in that situation. We're almost at the end, guys. Bear with me here. So our next question is, how does the deposit get released? So escrow will, in general, only release the deposit if they have something signed by buyer and sellers, or if it's pursuant to a court or arbitrator order. So what if the seller won't release the deposit when you have a buyer cancellation under a contingency? Here's some tips of what the buyer's agent could do. The buyer's agent can use the car sample letter library. The way you find that is in zip forms under form libraries. You click the little blue triangle and you drop down to where it says car sample letters. There's a letter in there called demand for deposit for contingency cancellation that can help put some pressure on the seller. Now, if the seller still won't sign, at that point, you have to advise the buyer to consult with the buyer's own attorney because the buyer's probably going to need to sue for the deposit. Agents cannot sue the seller for the deposit. That is something that the buyer has to do. And let's talk about the reverse. What if the seller won't release a deposit for a buyer cancellation under a contingency and you are the listing agent? If you're the listing agent, you could advise your seller, hey, can we reread this section of the purchase agreement? You should talk with your own attorney. You could advise the seller that they might have difficulty selling to a new buyer without the cancellation of this escrow. Escrow companies may refuse, there could be title issues, that sort of thing. You could maybe see if the buyer will agree to a partial release, which is provided for in car cancellation. Section 2D talks about partial releases. If you have that situation where there's been a cancellation, but the deposit is not yet settled, so the escrow is still open, the MLS rules vary about if you can make that listing active again while you still have that open escrow. But almost all of them require some kind of a disclosure of that outstanding escrow. So in some of them you can be active, but you have to disclose that outstanding escrow. And in other MLS rules, there's different statuses that it has to be. So check with your rules. And last but not least, you can advise seller with a car sample letter called receipt of subsequent offer. What that says is basically, hey, I recommend to you, seller, that any second offer that you're going to accept be subject to a cancellation of the prior contract in escrow, or that you should seek advice of legal counsel seller. The reason for that is because you don't want to put your seller in a situation where they have buyer number 1 and buyer number 2 both suing them, saying the property should be mine. That's what you definitely want to avoid. But also, honestly, if you're in that situation where there is a buyer or seller refusing to release a deposit, that is one of those great examples of when people should be calling us, and what kind of we're all about with the Legal Lifeline Club, because there's sometimes things that we can do to help your clients, or really to save the transaction depending on the situation. Here's our contact information, and here's another link again to join the Legal Lifeline Club, where you can input your information and we'll send you the exact quote, the pricing for our special EXP agents pricing and that sort of thing. There's also our social medias on there. And that is it, guys. We're going to open it up to questions.
Hey.
This was a lot.
A lot of good stuff. Kristen, thank you so much. That was absolute fire. I definitely, that was extremely valuable. So thank you so much for sharing. I think everybody graduated like white belt, yellow belt, maybe orange belt. I don't know where in the ninja scale everybody's at right now, right? But
straight to black belt, guys. We don't
there we go. Exactly. So thank you so much. Extremely good value. But guys, is there any questions that you guys have? Also, make sure you guys contact, Kristen, and that way you guys can have her. I think the legal hotline is extremely valuable, right? If you definitely want to have somebody that's going to be there side by side with you guys. So make sure you guys are tuning in. But questions, let's open it up for questions. We got 4 minutes.
Hi, this is Amesco over here from Palmdale. Kristen, I just wanted to tell you, thank you so much for helping me out in all of my career with everywhere we've been together. So thank you so much. She's a beast, guys. If none of you guys ever work with her, please lean on her. She is such a powerhouse.
Right? Like,
yeah.
so you need the beast, all in one.
You're the best. You're the beast. You're all there. Trust me. You got everything down. You've always backed me up. I appreciate it. So thank you so much. That's all I wanted to say. I don't have any questions. Thank you so much.
Thank you.
I appreciate it. Honestly, that's like the pleasure of my career, and really like why we started this law firm, and what we're all about is really helping those agents and saving those transactions, and trying to do it in a way that's like super cost effective for agents, especially with how uncertain the market is. We wanted to make it where basically you pay us when you close escrow. So we are on your side. We are working hand in hand with you, kind of like the way that you would with a TC. And it only costs about as much of a TC, if not less, really, for EXP agents.
Yay, that's awesome. And guys, this has been recorded, so everybody's going to get a copy of this recording, because there was a lot of stuff that was shared. So if you guys want to go back and then replay it, pause it, and all that good stuff, you guys are going to have full access. And I'll make sure in that video link to include Kristen's information, how to partner up with them as well. But
can I share with you the slides too to email out, because I know we're seeing some questions on that.
Oh yes, please. Yes, that'll be fantastic. If you could send those over, I could definitely put that in there. Looks like Mr. Mo has a question. He has his hand raised. What's up, bro?
I'm gonna take advantage of this this time, Kristen. Question for you. I know we're talking about contingencies and things like this. What happens, right? Like at the close of sale. And I mean, I think that's something that's I'm running into in the last, especially with these rains right now, is roof issues, right? These 2-year shirts. I mean, does that fall within the transaction? After the transaction, like it literally happened to me like last week, right? Close the deal, rains happen, Friday, Saturday. Well, I did my VP, house is good. Saturday comes in, house is flooded.
Yeah.
Right? I mean, the 2-year shirt, how does that work? I mean, is that something that falls within our, within once we're close for us? How do we guide our clients through that? I mean, because obviously we have pissed off buyers now, right? We're trying to help that out. So just kind of give us some light on that. And yes, I'm signing up. We're gonna reach out to you. So
rain really depends on the situation, right? If it is a situation that occurs before close of escrow, right? You're in a very different analysis than if it occurs after close of escrow. If it occurs before close of escrow and there's some kind of like roof leak or flood or that sort of thing, like there's definitely a duty to disclose that, right? There's like, you're not getting out of that. There's a duty to disclose, and that could trigger some buyer cancellation rights. When we see the kind of like hail in Southern California that's so like abnormal and abnormal amounts of rain, that could arguably also trigger what we call like force majeure or like act of God, and different rules apply for that. So when you have like this like act of God, it depends on, and they call it like, the quote is like irresistible superhuman cause. That's what they call it. When you have something like that, it depends on like if the property was materially destroyed because of it, or if it's like some smaller issue. If you're in a like the property was materially destroyed because of it, then there's some arguments that like buyer or seller could cancel, and then there's other arguments that says that just the seller could, and or that just the buyer could. Like it really depends on the very specific back situation. And also there's like laws that have conflicting information. So if it's during escrow, I would say like call us so that we can get into like the nitty gritty details, because it's really going to depend on like what kind of damage are we talking here. In general, though, you'll probably have a disclosure, and in general, if something goes wrong during escrow, that falls under the part of the purchase agreement that talks about the seller has to maintain the property in the same condition that it was in, that sort of thing. That's usually what's going to apply, but not always. So that's why, like, give us a call. If it's after close of escrow, then the tricky thing with that is that a buyer's going to be angry, right? Hey, what do you mean? It like, you didn't disclose it. I didn't know, right? Like, I don't have a crystal ball. It is a situation where you very often see a buyer trying to sue over it, and you have to be very cautious of how you work your way out of it. But typically, like, the direction that you're going to want to point the buyer into then is, you know, if there had been like that roof inspection and that roof certification, here's their contact info, contact the roof guy. They're the experts, see what they can do. Was there some warranty or something? Maybe they can do it. And otherwise, it's really going to be like the buyer needing to call the buyer's own like home insurance on it, because the seller doesn't have home insurance on it anymore. That policy's already been canceled, right? It's the buyer's home insurance, and it's something that's new. But that's also one of those very fact specific and depends on like, was there some issue? Was it disclosed? Was there not? So that's like another, give us a call and we'll talk about like the nitty gritty of it. That's your general sort of guidance though.
Cool. Thank you so much, Kristen. Thank you, Mo, for the question as well. And we're at the top of the hour. I got to go to my next meeting, and looks like there's more questions coming in, but okay, quickly. Do you handle probates and foreclosure properties?
We're familiar in general with it. I mean, if you have a specific question for it, but by all means, and you know, generally, if we don't know the answer, we're pretty good at researching it and figuring it out.
Cool.
So I've definitely got like probate sales and foreclosure contingencies and things like that before.
Awesome. Make sure you guys follow them on Instagram, and you guys will get the copy of the recording. Thank you once again, Kristen. Appreciate you. And Sanam, nice to meet you. Thank you so much for being as well. And thank you all for tuning in, and we'll see you at the next class. I'm already getting some ideas. Let's get it. Thank you, guys. Thank you, guys.